Hey, everybody. Let me know if you can hear me. Hey, hey, hey. Let me know if you can hear me. Y'all, this is going to have to be either a 2 or a 3-part series. Thank you so much for the disclaimer. Appreciate you. This is either going to be a 2 or a 3 parts. I'm not going to try to do the whole the whole 160 something page tonight, because y'all know it's still a whole lot going on out here in these YouTube streets. But I will do a portion of it tonight, and then a portion tomorrow until we finish. Just keep on until we finish, okay? So y'all, the defense has filed a motion, his new defense team. Now, I have not went through here and read everything, right? However, what I did do, of course, was put it in ChatGPT and have them to spit out a summary. And baby, when I tell you, I knew this was going to happen. I knew that they were going to find all kinds of errors. And from what I'm hearing, there was a lot of things that were agreed to behind the scene that was not, I ain't gonna say legal, but it was what's the word? It was shady. Okay, so we're gonna go there. There was a lot of things that was asked, for or requested behind the scenes that was shady. Raise your hands if you have already heard this breakdown. Let me know. Have you already heard the breakdown? Because it's a lot. It is a lot. It's a lot. It's a lot. It's a lot. It's a lot. It is a lot. No one heard it? No one has heard the breakdown? Say something in the chat. Just let me know if y'all can hear me, because I'm not seeing the chat moving. Just to make sure we good on this end. She says, can they get in trouble for that? Okay, I see y'all now. Possibly, yes. Down to the judge. Yes, it looks like, it sounds like that he may have had some involvement in the agreements and the lack of in dealing with this. Okay, so we're gonna go from the top. I'm gonna put it up. Hold on. I asked for it to give me a summary over here, but I don't think I'm gonna take that summary because I asked ChatGPT to do it as well. Here's a summary over here of everything this document is saying. However, I'm not gonna take that summary. I already paid for ChatGPT, so we're gonna go there. All right, we're going to go word from word, line from line. No, we're not going to do word from word. Let me take that back. But we are going to cover what everything is about, okay? So, first of all, let me just put this up here. Y'all know that Karmelo Anthony got a new legal team. He had a, not public defender, but it's kind of like a public defender, but a state-paid attorney, right? And this team right here, actually one is missing off of my thumbnail. Why they do that? So it's 1, 2, 3, 4, 5, 6 people. So my thumbnail missed the lady. So I'm gonna have them go back and put it on there. But nevertheless, and the lady works for Ben Crump. So my thumbnail is missing a person. I'm gonna move this banner. Basically, what I say out of my mouth is based on my opinion and my opinion only. But I want it. I'm gonna have to fix that, but I'll fix that after the fact, okay? But so they got a team of 6 new people. We already discussed those people, broke them down as far as where they work, what they do, what they're good at, and how they're gonna be assistant in this case. So this is the new team, and the lead is Russell Wilson II, and that's the guy right there with the afro that's standing, adjacent to Karmelo Anthony, okay? So now let's go right into it. Now, this is going to be a long thing. We're only going to cover so much a day and then pick right back up tomorrow. So right here, this is the state of Texas versus Karmelo Anthony. However, this defendant's motion for a new trial brief. Now, I think I told y'all that this is one of the first steps they take before filing an appeal, okay? So they're asking for a new trial. Most likely, to be honest with you, well, I'm not gonna say that. I ain't gonna say they're not gonna get it. What I will say is, hey Camille, what I will say is this is procedural. So don't, get all wrapped up like, oh, they asked for a new trial. That mean they're gonna get a new trial. That's not necessarily true. But asking for a new trial in so many days, they had so many days to ask for a new trial, and they met the deadline. So to ask for a new trial. This is only step one. They ask for a new trial. If this is denied, then they go to the appellate court. But at least they would have been able to bring up all of this argument in order to take it up to the appellate court. Okay. So they're asking for a new trial. If they are denied, and I also want to say they're asking for the judge to be taken off of this case. However, I'm going to let you know as I go through this, okay? Hold on, because I had up. Give me a second. I had up. Let's take this down. Let me take some of this stuff down because I had up. Oh, girls. Okay. All right, I'm gonna take that down. Okay. So again, the steps asking for a new trial. If that's denied, then they will be able to go up to the appellate court, and from the appellate court, they will, bring up a lot of different things. And then from appellate court, depending on what they say, then they would go up to the Supreme Court. Okay. Same thing that just happened in the Holly Johnson case, Kadeja Johnson. So right here it says defendant motion for new trial and brief in support. So to the honorable judge of said court, come now defendant Karmelo Anthony by and through the undersigned counsels and, of Texas rule appellate procedure moves to court to set aside the judgment of conviction and sentence granted for a new trial. So what they're doing, they are asking the courts to set aside that judgment. They're really saying, they are literally really saying, we don't think that Karmelo Anthony had a fair trial. So we're asking you to set aside the judgment and the sentence and grant a new trial. The defendant moved for a new trial on 4 grounds. First, the count committed structural errors when it materially restricted public access in violation of the rights to a public trial. So right there, they're saying, and I'm going to, have ChatGPT to help me out, but basically they're saying that this was supposed to be for the public as well. Okay. Now, ChatGPT said this is their strongest argument. Okay. Public trial violation. This is the defense's biggest and cleanest argument. They claim that the trial was supposed to be public, but in reality, access was so restricted that the public was materially excluded. The motion says the general public only had a 10-minute entry window. Media was capped out. Seating was very limited, and the doors closed at 0900 hours, which is 9 o'clock in the morning. And there was no overflow room available except for doing jury selection. Other than that, they closed off all overflow rooms, no audio feed, and no video feed for people who could not get inside, which means that this was so locked down that nobody, unless you was in the courtroom, really knows what was going on. It goes on to say the defense said the courtroom had roughly 70 seats, but after family, media, and court staff took their seats, only about 24 public seats remained. The judge later allegedly confirmed that there was about 27 to 32 public seats rotated daily. Now, the biggest issue in this is the court reportedly had an overflow room available during the jury selection, but then removed it once testimony began. The defense said that overflow room was available on June the 1st and June the 3rd, but eliminated on the first day of testimony, which was June the 4th, with no open court announcement, no order, and no filings. That matters because a public trial violation can be structural error. A structural error is powerful because the defense does not necessarily have to prove this changed the verdict. They argued that if the public was wrongly excluded, the remedy can be a full new trial. The motion says because the alleged closure affected the jury selection, guilt, innocent, and punishment, the proper remedy is a completely new trial, and structural error does not require a showing of prejudice. So, right here, this is the best issue that the that the new team is setting up right now. If the judge really did restrict public access without proper finding and without consideration, reasonable alternative, this is the argument most likely to get serious attention on this appeal. Now, I'm saying that because a lot of people probably say, this don't sound like it's a big issue. It sounds like it should be because the jury selection didn't have black folks. We getting there, but right now, see, we don't know this because we're not attorneys, right? We wouldn't have known that it was in a violation for Judge Roach to close off his courtroom. We didn't know that. We just take orders and we keep it moving, right? But these attorneys, because they know the law, they know this shit. They know that it is a violation for the judge to block off access to the public every which way when there was opportunity for the public to hear what the hell was going on. There was an overflow room available for 2 days. Actually, yeah, 1 through the 3rd. Well, it was the 1st, then it was off the 2nd, and then the 3rd. So they had overflow room for 2 days, but all of a sudden on the first day of the trial, now we don't want to use the overflow room. That's a no-no. They did not allow cameras in the courtroom. People had to bring their paper, and then they limited to 9 media, 27 public seats, and then family and friends, okay? So again, we're not attorneys. We would not have even thought for a moment that that was a violation, but there is a such thing as public trial violation. And apparently this team leading with Russell Wilson said that Judge Roach violated this the trial to be public, and therefore a new trial should be granted. That's their very first argument, you guys. Now, let's get to the second argument. On the paper, it says, hold on. The state's what's that word? Repudiation of the parties unrecorded adventure. Oh, I don't know what that means. Evidentiary agreement. I'm sorry, y'all. So let's start over. The state's repudiation, I don't know what that word stands for, of the parties' unrecorded evidentiary agreement after defense relied on it, okay? And he coerced a waiver of Mr. Anthony's right to testify and denied him a complete defense in violation of his constitutional rights. So let me break that down, because y'all know sometimes these words have more than 3 syllables, be messing me up. This is what it says. The second argument alleged off-record agreement. Now, this one is also serious, but it's harder to prove than the first one, okay? The defense is saying that there was an unwritten agreement between the state attorney and Mike Howard. So the defense team tried the case clean. So meaning both sides would avoid character evidence, reputation evidence, and extraneous bad acts, evidence about Karmelo or the Metcalf twins. The motion said this understanding was discussed in meetings and presented to the courts in chambers off the records. So what they are saying is, they're saying that there was an agreement that they would not come forth with Karmelo Anthony's dirty laundry that happened at high school if they did not dig into the characteristics of the Metcalf twins. So let's keep everything hush-hush. So I had heard that Karmelo was involved in some type of fight or something, tussle or whatever at school. I had heard that before, right? However, I don't think that would have mattered, But because he was involved in some type of fight at school, the defense attorney, Mike Howard, agreed with the state, the prosecutor, that we won't bring up the fight that Karmelo Anthony had if you don't tell that the Metcalf twins are criminals. Oh, y'all didn't know that? Oh, we ain't got there yet, right? Oh, okay, my bad. Let me slow down. Let me slow down. Let me slow down, okay? All right. It says, the motion said this understanding was discussed in meetings and presented to the court in the chambers off the records. So, according to the defense, they relied on that agreement. They said they changed their strategy because of it. They did not ask certain questions, did not bring up certain aggression themes in the opening, did not cross-examine some students' witness statements about Austin and his brother being aggressive or being bullies, and did not call certain experts. Ooh. So they made it a dumbass agreement to not call certain experts, to not reveal that some students did say that Austin and Hunter was aggressive and bullies. So they agreed. The dumbass defense attorney agreed that if you don't bring up Karmelo Anthony's background, then we won't bring up Hunter and Austin's aggressive behavior. We will not ask the witnesses certain questions about Austin's aggressive behavior. So then, according to the motion, on June the 8th, the final day of evidence, the state said the agreement never covered Karmelo testifying. The judge allegedly said he did not know how to enforce the off-the-record agreement and warned that if Karmelo testified, the door to character, extraneous evidence would likely open. So the defense says Karmelo was only given 10 minutes to decide whether to testify or not. And he chose not to because the judge pulled the motherfucking plug on him and said, if you testify, then I cannot say that your character and the things that you've done will not come out during your testimony. I don't know how to protect that, is what Judge Roach said. So he gave Karmelo Anthony 10 minutes to decide. If you get on that stand, they may find out that you were involved in some type of altercation prior to this one, okay? And that may hurt you. So in 10 minutes, he had to choose whether he wanted to testify or not, and he chose not to, okay? So the defense argues this basically silenced him and hurt his self-defense claim because his own perception of danger was central. So now this is emotionally and legally powerful, but it depends heavily on the proof. The problem is that the alleged agreement was not clearly on the record. The defense knows that. So they are asking for an evidentiary hearing where trial counsel and maybe the prosecutors can testify under oath about what the agreement was. Okay, bring your lying ass to this hearing and spell out what the agreement that we made, because now you're trying to act like it didn't exist. The motion itself says the existing terms and I don't know how to say that word. Repudiation of the agreement. Let me find out how you say this word, y'all. Hold on. When words tie me up like this, I have to find out how you pronounce it. Hold on 1 second. I'm sorry, y'all. Hold on. How to pronounce this word. It might be easy as hell, but let me see. Okay, let's listen to it. Well, what the hell is it?
Repudiation.
Repudiation? Okay. Repudiation. Okay, I still can't say it. Repudiation. Okay, repudiation. All right. So anyway, it says the motion itself says that the existing terms and repudiation of the agreement cannot be determined from the current record and need a hearing. So they need to set up a hearing with possibly the prosecutor and Mike Howard and the motherfucking judge, because he was involved, and say what was really said. We knew here. We the big dogs now, right? Tell me what exactly was said. Everything that was said. So they are asking for a hearing to determine what exactly was said. All right. So this could help Karmelo, but it's not clear as the public trial issue. It's not as clean as the public trial issue. So meaning, number one, if they can prove that the judge made the public close it off and shit like that or whatever, that's a stronger argument than number two, is what it's saying. Now let's go into number three. All right. So the third argument that they are bringing forth for a new trial is that the trial court improperly instructed the jury on the applicable law. And I was wondering, I said, what was the judge's rules? What did he say? What did the judge, give them the instructions? So it says, third argument, bad jury instructions on provocation. Now, this is a huge one, okay? Karmelo's defense was self-defense, okay? The motion says the jury was instructed on provoking the difficulty, which can limit or remove a person's rights to claim self-defense. If the jury believes the defendant intentionally provoked the confrontation as a setup in order to use force against Austin, right? The defense argued the judge should not have given them those instructions because there was no effing evidence that Karmelo had preformed plans to provoke Austin so he could kill him. There was no evidence of that. They admitted the state could point to things like Karmelo staying in the area after being told to leave, exchanging words with these people, having a knife in his book bag, or being involved in the confrontation. But they argued that ain't enough. It's not enough. They say provocation requires evidence that he intentionally created the situation as a pretext to use deadly force. They have to have proof that he set up the situation. He went to the bleachers and waited till these boys approached him, and he knew all along that he was going to take his knife out and he was going to stick it in Austin's chest. And the defense is saying there is no proof that he planned to set this shit up, so you cannot give the instructions on provoking the difficulty. That shit should have been left out because that eliminated Karmelo's right to claim self-defense, okay? It says the motion also says that this error was preserved because the defense objected to the provocation instructions. And that's the state relied on the instructions in the closing arguments. So during the closing arguments, they kept saying he provoked him. He provoked him. He provoked him. He was the provoker or the provocator or whatever the case may be. All right. So the defense is saying wrong, wrong, wrong. It should not have been allowed. Okay. Now, this is probably the second strongest appellate issue. The jury charge errors can absolutely win an appeal, especially when the instructions directly affect the only real defense in this case, which was self-defense. Here, the defense says self-defense was the heart of the trial, and the provocation instructions gave the jury a legal path to reject self-defense. So the fact that he used provocation, and the law says if a person provoked the situation, we talk about this in other cases that we cover. If a person is the aggressor, they cannot claim self-defense. So by the judge allowing this prosecutor to say that provocation, provoking the difficulty, the fact that he was able to use this in the instructions to the jurors, he basically eliminated any type of self-defense claim of Karmelo Anthony. when you tell a jury that if a person provoked the situation, then self-defense is off the table, and then the judge turns around and give them the instructions of the provocation, then that is a violation, okay? So again, this is the second strongest appellate issue. Jury charge errors can absolutely win an appeal on this, especially when the instructions directly affect the only real defense in this case. The only defense that they came forth with was self-defense. That was the heart of the trial. And the provocation instructions from the judge to the jury is a legal path to reject self-defense. So the judge knew what he was doing. He knew he gave them instructions to take self-defense off the table, which means when the jurors went back there, it wasn't whether he was guilty or not. It was what he was guilty of. He was already guilty because self-defense was taken off the table through the jury instructions given by the judge. Okay? So again, it wasn't a matter of whether he was guilty or innocent. It was he was guilty, but let's talk about what the fuck, excuse my language, what is he guilty of? Okay? Now, let's go to the fourth argument from the new legal team. The fourth argument, it says here, the cumulative effects of these errors warrants a new trial in the interest of justice. All right, let's talk about it. This is a backup argument, right? So basically it's saying if all else fail, if everything failed, we got you on something else. The defense says even if the court does not believe any one issue is enough by itself, the combination of everything made the trial unfair. Number one, restricted public access. Number two, the alleged broken evidence agreement. And number three, Karmelo, number two is, let's start over. Number one, restricted public access. Number two, the alleged broken evidence agreements, which hindered Karmelo from testifying. And number three, the provocation instructions. So it says, with all else fail, all these combined together is enough to have said the trial was unfair. All right. So this is usually a just in case argument. The court do not always love these cumulative error claims, but it helps the defense paint the full picture. This was not only one tiny mistake. The whole process was flawed. Jack the fuck up. Excuse me. Jack the mess up. I cuss y'all. Okay. Now, let's talk about the deadlines. All right. The motion was timely. The motion says sentence was imposed on June the 9th of 2026. They were given 30 days to file the motion, which was July the 9th of 2026, and the court's 75-day ruling deadline falls around August the 23rd of 2026. So within the defense requesting a hearing ruling by Friday, August 21st to avoid deadline issue. That means that the trial courts has a limited window to act. If the motion is denied or not ruled on in time, these issues can continue into the appeal. So they were given 30 days and they met their damn 30 days. Okay, so they got it in enough time. All right, let's go to the next section. All right, so we talked about, now let's go to the background factuals in this case. All right, because even though, you know, we heard it, but we wasn't in court, so we didn't get the whole thing. All right, so they're asking for a new trial based on those four arguments. So then they given the factual background information. Hold on one second. Let's break down the factual background information. Give me a second. So we start with the case and the verdict. All right. Oh, shoot. Y'all doing good down there? So it said this case arises from an altercation at a high school track meet. The defendant, Karmelo Anthony, was charged by indictment with the murder of Austin Metcalf. alleged to have been committed on or about the date of April the 2nd of 2025 in the Collins County, Texas. The defendant pled not guilty. His defense at trial was self-defense. That he used force he reasonably believed immediately necessary to protect himself. Okay. The court submitted the offense of murder, the lesser included offense of manslaughter, and the law of self-defense, including the justified use of deadly force. The defendant did not testify. On June the 9th of 2026, the jury found the defendant guilty of murder, and the court imposed a sentence of 35 years confinement. These matters appeared before the indictment, the court written charge, and the judgment. Okay, let's talk about it. All right, let's talk about it. So it says, okay, so I read that part. All right, let's continue. So number 2, the case arises from an altercation at a high school. Oh, I just did that. Number 2. Okay, the case drew national attention. The defense says this case became nationally watched from the beginning, so the court appointed a public information officer to help with media credentialing, communication, and access logistics. In practice, the defense says public and media access were controlled through that process. Okay, this is important because the defense is setting up their argument that access to the trial was not just limited by the courtroom size, it was controlled by a court-created procedure, meaning that Judge Roach assigned somebody to come in there and control all the access of who received what information. It was controlled by court-created procedure. Judge Roach created this shit. So number 3, okay? Well, it's really number 4, but over here is number 3. So number 4, the gag order before trial. The motion says the judge entered a gag order on July 28th of 2025 without a party even asking for it. The Judge Roach, did this on his own reconnaissance. The gag order applied to the parties, attorneys, witness statements, the law enforcement, courthouse staff, court-appointed officials, the family, the friends. It restricted them from publicly discussing the facts, the evidence, the witnesses, the credibility, the guilt, the innocence, or expected testimony without written approval from the court. So the judge shut everybody up, said nobody can say shit about this case. The defense argued that gag order helped keep the case out of the public's view before trial. They also said that the order had only short findings and did not recite evidence supporting it. There was no reason for them to shut this down, is what the team is saying. Why you shut it down? The defense didn't ask for it to be shut down. The prosecutor didn't ask for it to be shut down. The judge took it upon himself to shut down everybody from talking about this case. Everybody. The judge did that on his own. Let's continue. Pretrial work allegedly happened. So let's talk about, we talked about the gag order. Now we're talking about the pretrial work, okay? The pretrial work allegedly happened out of the public's view. Now, this is a big part of the background. The defense team is saying important pretrial conferences happened in the chambers of Judge Roach outside open court. So Judge Roach had people back there in his chambers talking about some shit that don't nobody know what the hell it was about. That included a May the 21st of 2026 conference where the alleged evidentiary understanding was described to the court. And then on May the 29th of 2026, the meeting about the trial security and scheduling. So the motion says there was no reporters present for that meeting, no pretrial hearing on access restriction, and then the public document did not show substantiated pretrial litigation. So which means in plain English, the defense is saying a lot of important shit happened in Judge Roach's office chambers behind closed doors, and the public could not see for themselves what the hell was taking place. We don't know. We don't know what happened. They probably signed some shit over. We don't know what happened, y'all. We don't know if the damn defense attorney fucking signed over Karmelo Anthony's rights out of the presence of the public, out of the presence of everybody, right? Just them in the judge's chamber. So no reporter was there to even say, oh, no, yeah, they talked about this or they talked about that. No, wasn't nobody there. Wasn't nobody there. Let's continue on. So the next one is the amended order, the written terms of access. All right, it says, oh, that's an Amber Alert. Sorry, y'all. It says the amended trial access order. On May the 18th of 2026, the court signed an amended order controlling trial proceedings, media access, security, and decorum. The order says the courtroom will open up at 8:30 in the morning for media to come in, 8:40 in the morning for the family to come in, and then at 8:50 a.m. for the general public. Doors closed at 9 o'clock. Late arrivals could not enter until recess, and people who left could not re-enter except at recess. The defendant team is saying there was no overflow room, no audio feed, no video feed, or way for excluded members of the public to object. Okay? So basically, they saying that the judge was wrong, all the way wrong for that shit. Okay, now the courtroom curfew and pre-dawn lines. The order also placed the courtroom. Hold on, let's get to that one. Right here. Sorry, y'all. Curfew and the parking lot. That's what we own. The curfew in the parking lot. So it says the defense said, oh, hold on. The order also placed the courtroom campus, including the parking lot, the sidewalks, and the green space under a curfew of 11 p.m. at night to 6 a.m. in the morning during the trial. The defense says people still started arriving at around 4 to 5 o'clock a.m. because seats were so limited. Deputies allegedly stopped people at the parking lot until the curfew lifted. The defense points is that the official public entry time was 8:50 a.m., but realistic, if someone showed up at 8:50, they had almost no chance of getting in because the real line formed earlier. The real line started at 4 o'clock in the morning. Let's just call a spade a spade. Y'all know I was there, and that shit is true. People were literally dashing across the goddamn parking lot to get to the courthouse door. So he's right. He's saying, the defense is saying, it said on the paperwork that it started at 8:50, right? But it really didn't start at 8:50. That shit started at 4 o'clock in the morning. If your ass was standing out there at 4 o'clock in the morning sucking your fingers, you wasn't getting in to that damn courtroom, okay? You came at 8:50 like we did on a day one, and we got there earlier than that. We got there at 7 something and still had to be marched around like little ants down the hall, okay? So the defense point is that the official public entry time was stated at 8:50 a.m. But realistically, if someone showed up at 8:50, they had no chance of getting in because the real line formed at 4 to 5 o'clock in the morning. All right. Now, the next one says the lines allegedly was not handled fairly. Ooh, baby. Talk. The defense said the line was administered without clear standards. They claimed some people were moved ahead of others who had been waiting for hours and hours and hours. They named Thelma Anderson, who allegedly arrived. Oh, Thelma, that's the judge that I interviewed, y'all. Thelma Anderson is the judge / prosecutor that I interviewed, who allegedly arrived early and was around 7th in line, but got pushed back to around the number 35 and missed the morning procedures. Okay. They also mentioned Tamitra Carter, who was allegedly number 7 on the early arrival list, but was removed from the line on June the 5th, and she missed the morning session as well. This supports their argument that public access was not just limited, it was chaotic as hell, and it was uneven. All right. Now let's continue on. It says only about 24 public seats were available. All right. So the courtroom had about 70 seats, according to this motion. 15 were for the prosecution family, 15 was for the defense family, 9 was for the media, plus court staff, leaving only 24 public seats. The judge allegedly later confirmed there was about 27 to 32 public seats rotated out each day. The defense also says Karmelo Anthony's own family was allegedly limited to only 8 seats, meaning his grandfather and aunts were excluded. They couldn't even be there for their son. The grandfather and the aunts had to go, y'all. They had to go. Let's continue. So the next one, overflow room exists and then it disappeared. Right here, I think we spoke about this. They had it on day 1. There was no court on day 2. And then day 3, they also had the overflow room. But the defense is saying right here that the court provided an auxiliary viewing room during the jury selection on June 1st and June 3rd, where members could peek through the damn window and see what the hell was going on inside of the courtroom. But on June the 4th, the first day of the testimony, that overflow room was taken away by Judge Roach himself. The defense is saying no open court announcement, no modified orders, and no finding explaining why. In plain English, he said uneffing acceptable. The public could watch overflow when no witnesses were testifying, but once the evidence started, the overflow was gone. That's a violation, 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 violation. Let's go to the next one. Day-by-day access problems. The motion lays out a timeline. Let's go to the day-by-day screw-up that they had here. It says the motion layout on June the 1st during jury questionnaire, an auxiliary viewing room was available. On June the 3rd, during voir dire, the overflow room was operating. On June the 4th, testimony began and the viewing room was taken away. Only 27 people were admitted from a line of about 80 to 100 people. But on June the 5th, there was still no damn overflow room. June the 6th, the state rested their case and the defense began. One person was allegedly displaced in line and another removed for expressive clothing. They wore clothing that said support somebody, whatever. So on June the 8th and June the 9th, the same, no overflow, no audio, no video, no system, allegedly remained in place through closing verdict, punishment, and the sentencing. The public didn't get to watch none of it. They didn't watch the open. They didn't watch the arguments. They didn't watch the closing. They didn't watch the verdict. They didn't watch the punishment. And they didn't watch the sentencing. So day by day, Judge Roach shut it down to where the public couldn't see nothing that was going on. Nothing. All right, let's continue. Excluded public members. The defense listed several people who allegedly tried to attend but were excluded. Jacqueline Yon traveled from North Carolina and found a line of 80 to 100 people with only 27 admitted. Taria Allen flew from Arizona, watched the jury selection from the overflow room, and then was excluded after the overflow room was removed. Bridget Smith confirmed the 27-seat cap and then removed and the removal of the outside viewing location. Kiara West was allegedly turned away and later removed because of her clothing. Thelma Anderson was excluded on June the 4th and the 5th and only got in mid-afternoon on the 6th. The motion also says those people did not observe disturbances or security incidents that would explain these harsh restrictions. Like why? Why? Tell me why you had all these restrictions, okay? So going right along, it says the alleged unrecorded agreement. Ooh, let's talk about the alleged unrecorded agreement, okay? The defense says prosecutors proposed trying the case clean, meaning both sides would stick to what happened under the tent and not bring up character, reputation, or extraneous conduct evidence about Karmelo or Austin. Child, this is where it's about to get good. Do y'all need to go get something to drink? Let's continue. It says the defense says the argument was discussed in May meetings and called present to the court in the chambers and kept off the public document. They said they relied on the agreement during voir dire, opening statements, cross-examination, expert decision, and the trial strategy. For an example, they said they did not cross-examine student witnesses about statements that Austin was aggressive or easily triggered. The boy had a badass temper, y'all. He had a bad-ass temper, and there was witnesses there to testify that the dude was just aggressive. He was easily triggered, okay? Big time aggressive. It says here that Austin Metcalf was kind of like the aggressive guy on the team, that he got triggered, that Austin and Hunter, they're not going to let you disrespect them, okay? And that if Austin is about to get in a fight, you can tell, and that he could be a bit aggressive at times. And in an abundance of caution, even narrowing the question into understanding permitted. The defense designated no experts, foregoing a neuropsychologicalist prepared to examine how the defendant's epilepsy affected his perception of the threats. Now, y'all, let's stop for a moment. We asked, where is the neuro doctor that can testify on Karmelo Anthony epilepsy? Did we not say that? Did we not ask, where is the doctor that's there that can say the fact that he had epilepsy, that he probably was scared that one hit, that he would have some type of seizure and could possibly die? We asked about that. Now we found out that there was an expert there, but that bullshit ass agreement that they made don't bring up anything about Karmelo, and we won't bring up anything about Austin. And then on top of that, they said, okay, well, if you do that, then take away this witness, and this witness that says Austin is an aggressive person and easily triggered and don't like being disrespected, right? But furthermore, on top of that, they also said, oh yeah, and also eliminate this expert right here that talks about how Karmelo Anthony's epilepsy could affect his perception of perceiving a threat. And also on top of that, a forensic psychologist prepared to address adolescent brain development and fight or flight responses, because the state took the position that such testimony would breach the understanding. So 2 experts was eliminated. The damn witness there that says Austin don't like being disrespected, and he was kind of the aggressive guy on the team, right? And you can tell when he's about to fight. So punk ass Mike Howard, defense attorney, agreed to this shit. He went in a chambers. This wasn't done in no courtroom. This wasn't done during no trial. This was done in Judge Roach's court chambers, okay? In the chambers. If you agree to take off the witnesses that says that he is an aggressive and he's easily triggered, just like somebody else we know, right? So if you take that off, and then you take away his neurologist that talk about his epilepsy, and then if you take off the forensic psychologist to address the adolescent brain development, right? Then we won't bring up Karmelo Anthony fight at school. Do y'all see this shit? His lawyer agreed to this shit. What lawyer would take off everything that, to me, they took off that I'm hearing of could have possibly showed how he was thinking that day, why he felt the way he did that day. You got an aggressive ass, easily triggered ass, don't like to be disrespected, big ass, 200+ pound dude there, right? Easily triggered, right? You want people to not talk about him being aggressive, right? Witnesses that was there to testify that this joker was aggressive. And then the expert witnesses that Karmelo Anthony parents paid for, now all of a sudden they can't testify on his behalf. Get the F out of here. Get the F out of here. Hold on. Now, let me go back to it. It says, they said that they relied on this agreement during the voir dire, opening statement, cross-examination, expert decision, and the trial strategy. For an example, they said they did not cross-examine students, witnesses about statements that Austin was aggressive or easily triggered. Okay, now let's go and talk about, and this also, with this agreement, y'all, are y'all ready for this? With this agreement, all because they wanted to not speak on Karmelo Anthony having an altercation at school, this also will eliminate Karmelo Anthony rights to testify, y'all. All along, we was asking, why didn't Karmelo Anthony take the damn seat, take to the stand? He was supposed to, y'all. Do y'all believe that? Karmelo Anthony was prepared to testify. Karmelo Anthony was prepared to testify. He found out at the final minute that he was only given 10 minutes to decide whether he could testify or not, because the judge came back and said, I cannot guarantee you, after we made this agreement in my chambers, I cannot guarantee you certain things that you say out of your mouth during your questioning will not lead to expose what your past is or what type of incident you have got into. Ain't that some bullshit? They played him. You absolutely right. They waited to the final minute for the judge to say, wait a minute now, I can't guarantee you that that can of worms won't get open. Why, you understand? I cannot guarantee you that. So you need to make up your mind. If you get on the stand, there's a great possibility that they may go down la la land with your ass, okay? I cannot guarantee that that would not happen. They gave a 19-year-old young man 10 minutes to make a decision whether he wanted to take a chance of them opening up that or not. Y'all, he was prepared to testify. Let's go into it. It says, the forbearance had a purpose. The payoff was to come in the defense case under understanding, as the prosecution itself repeatedly described it, covering all witnesses to what happened under the tent. The defendant would testify to the altercation like any other tent witness, free of character impeachment, and the defense would present its self-defense case through him. Every pretrial discussion presupposed it. The prosecution repeatedly raised the ambiguous aggressor doctrine, the doctrine that mattered only in a self-defense case built on such evidence. And as trial counsel has sworn in this case, the defense would ordinarily depend on the defendant's own account of his perception of the threat. Okay, let me see what it says over here. It says the defendant says, wait a minute. It says the defense says they expected Karmelo to testify about what happened under that tent like any other witness. But on June the 8th, the final day of evidence, the state allegedly said the agreement did not cover Karmelo Anthony testifying. The court allegedly said it did not know how to enforce the understanding and warned that if Karmelo testifies, the door of his character or extraneous offense evidence would likely be open. Man, they scared him is what they did. Karmelo was then given about 10 minutes to decide and chose not to. The defense says that was devastating because self-defense depends heavily on Karmelo's own perception of the threat. Let's go a little further. On Monday, June 8th, the final day of the evidence, after defense had spent voir dire is opening the entire cross-examining of the state case, and the first day of his own case honoring the bargain, the lead prosecutor announced that the agreement had never contemplated a testifying defendant and asserted that the defense counsel had already opened the door by mentioning in the opening that the defense played chess, a position the court itself rejected. The court then advised the parties that if it knew of no mechanism at its disposal to enforce their understanding, and understanding that throughout the months the defense relied upon it, exists at no record because it had been reached and presented to the court off the record. And if the defendant testified, the door to his character and extraneous offense evidence will almost certainly be open. Allotting only 10 minutes, the defense elected not to testify. By then, it was too late to conduct a different voir dire, deliver a different opening, or recross the state's witnesses. At a punishment, the defense case was reduced to 3 pre-approved questioning of the defendant's mother. The state, for its part, called no punishment witnesses and offered none of the extraneous offense of character evidence cataloged in its 75-page notice, resting its punishment case immediately. Exactly as the lead prosecutor has described on May 11 that the agreement will operate. Exhibit 10, the state's punishment presentation will be confirmed by the reporter's record. The state thus performed the bargain at punishment the day after denying that same bargain covered the defendant's testimony. In the end, neither side put on character evidence. The understanding covered. The bargain was performed on both sides through the last day of the trial. The only terms repudiated was the one most viable to the defense, the defendant's own testimony. Karmelo Anthony was necessarily a witness to what happened under the tent, under the understanding that the state itself had repeatedly described it. He would testify like any other tent witness, and his elimination as a witness was devastating to a defense that turned on his own perception of the threat that he faced. By then, the defense had already paid the price of reliance and could not undo the voir dire. Opening, cross-examination, expert designation, or decision framework that had followed from the understanding, which means that because they withdrew this at the last minute or said that his testimony would not be protected, meaning that if he would have went up there, everything would have opened up, that he would not be protected. But the fact that he did not go up, the expert witnesses that he had in defense of Karmelo and 3 other witnesses that say Austin was a fucking bully was eliminated. Shut the front door, the side door, the back door, and the window. Okay? They knew Austin was a bully, and they kept the agreement all through the state's case, the state side. When they shut down and the defense started, that's when the judge threw up, I cannot protect you. I cannot protect you, defense, but he protected Austin. Did nobody hear that Austin was a bully? Did nobody hear Austin had a temper? Did nobody hear that these boys even had a criminal record? And we're going to get into it, okay? Now, I'm going to skip ahead just a little bit because I want to talk about it, okay? Can we break down the exhibit, hold on, of 75 pages? We're not going to do this whole thing today. I do want to break down the 75-page exhibit. Hold on. Okay, it's not a 75-page. It says what we do have as a defense motion, Exhibit 10, which is a trial counsel Mike Howard affidavit explaining what that 75-page notice was, how it was discussed, and why it matters. What is the 75-page notice? All right, so apparently there was a 75-page notice in the affidavit. Mike Howard says, okay, hold on. Ooh, Austin behavior. Ooh, let's talk about it, y'all. Y'all ready? Let me know if y'all still with me. Are y'all ready to talk about? We're going to break it down. We're not going to go all 75 pages of this particular thing, but we are going to hear. It says right here, it says, what is the 75-page notice? The 75-page notice appears to be the state document listing extraneous offenses, bad acts, character evidence, reputation evidence, school discipline, phone contacts, and other damaging information the state might try to use against Karmelo Anthony. In the affidavit, Mike Howard says that on May the 8th of 2026, the prosecutor gave the defense a documented title, State's Notice of Intents to Use Extraneous Offenses. At the same meeting, the defense gave the state its own motion about character trait evidence, the ambiguous aggressor rule, and Article 38.36 evidence. So this was basically both sides saying, the state, we have bad act character evidence we may use against Karmelo Anthony. And then Mike Howard, the defense, came back and said, well, we have violence, bullying, and racism evidence that we may use about Austin and Hunter Metcalf. Now what? The hell? Now what? Right? Y'all, are y'all with me? Are y'all with me? Y'all gotta wait the hell. Y'all ain't ready for this. Y'all ain't ready for this. Y'all ain't ready for this. Y'all ain't ready for it. 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 Y'all got to tell me in the chat, honey. I got 145 people in here. Y'all got to tell me that y'all are ready for this. Are y'all ready for this? So, again, the state said we have bad act character evidence that we may use against Karmelo Anthony. The defense said we have violence, bullying, and racism evidence that we may use about Austin and Hunter Metcalf. So this is why this became part of the alleged gentleman's agreement. What kind of evidence was in it? Well, based on the defense description, the state's notice including evidence about Karmelo's alleged character, reputation, extraneous offense or bad acts, cell phone content, school disciplinary records. So Howard's affidavit says the alleged agreement meant the prosecutor would not go into character, reputation, or extraneous offense, bad acts, evidence relating to Karmelo Anthony, including the context in his cell phone and school disciplinary record. The motion later summarized it as the acts itemized in the state's notice of intent to use extraneous offense. So we cannot list every item in that 75-page notice because the actual 75-page notice is not attached here. But we can say what category of evidence it covered: damaging character and bad act materials against Karmelo Anthony. Why is the 75-page notice important? Because the defense is saying this notice was basically the threat hanging over Karmelo Anthony's head. The defense claimed that both sides agreed not to use this kind of character bad act evidence. The state would not use Karmelo's bad act evidence, and the defense would not use Austin and Hunter alleged violence, bullying, school discipline, racism, or reputation evidence. In Exhibit 10, Howard says the prosecutor described the agreement as trying the case clean, meaning based on what happened under the tent that day, no character evidence will be brought forth. So that matters because the defense says they built their whole trial strategy around that understanding. The defense version of agreement, the defense says the agreement works like this: both sides would avoid any character, reputation, and extraneous bad acts evidence between both gentlemen. The trial would focus only on what happened under the Memorial High School tent on that day, April the 2nd, 2025. The defense would not bring up any damaging evidence against Hunter and Austin. In exchange, the state would not bring up any damaging evidence against Karmelo Anthony. Howard says the prosecutor called it a gentleman agreement, and it was made in Judge Roach's chambers outside of the public. The defense said they asked for clarification, including whether questioning witnesses about what happened under that tent would open up that door. So according to Howard, the prosecutor agreed that questionings narrowly tailored to what witnesses told the police about the incidents under the tent would not violate the agreement. So how sentencing and punish fits into this? This is the part that matters. Howard says on May the 11th of 2026, prosecutor Bill Werski confirmed the agreement will also extend into sentencing. But according to Mike, Whisker said that under the agreement, the prosecutor would quickly rest its sentencing case without going into allegations listed in the state's notice. This is huge because the motion later says this is exactly what happened. Okay? The state called no punishment witnesses, offered none of the extraneous offense of character evidence from the 75-page notice, and they rest immediately. The defense argued that this behavior proved the agreement was real. Okay. So in plain English, the state said, if we keep this agreement, we won't use the 75-page bad act notice at punishment. Then at punishment, the state did not use it. So the defense says, see, that proves the agreement existed. So they're saying there was an agreement not to bring up no reputational damages on either party, right? And, for the takeaway of Karmelo Anthony's testimony, and also to not question witnesses a certain way, and also to not bring forth two expert witnesses. Okay, had to be taken off the table to not bring forth the shit apparently that was found in Karmelo Anthony's phone, which we don't know what the fuck it was. So anyway, it says why the defense says the state conduct is suspicious. The defense argument is not just the state had the 75-page notice. It is that the state allegedly used that notice to threaten to keep Karmelo Anthony from testifying. All right. They're saying the judge says, I know what we agreed to in the chambers, but if you testify, I cannot say that can of worms would not come open and all the bullshit that you've done would not be revealed. Okay. So they used it to threaten him out of testifying on what happened on that day. Okay. So it says, here's a timeline. On May the 8th, the state gives the defense the extraneous offense notice. Both sides discuss a clean trial agreement. But on May the 11th, according to Mike Howard, the prosecutor says the state, not Mike Howard, I'm sorry, Howard. The prosecutor says the state would quickly rest at punishment and not use the notice if the agreement stayed in place. But on May the 21st, both sides allegedly explained the agreement to the judge in the chambers. But during trial, the defense holds back from using character evidence against Austin and Hunter. On June the 8th, when Karmelo is expected to testify, the state allegedly says the agreement did not cover a testifying defendant. The judge allegedly said he does not know how to enforce the agreement. Karmelo Anthony does not testify at punishment. The state does exactly what the defense said the agreement contemplated. It rests without using the 75-page notice. All right. So what the defense gave up because of this agreement, because of this bullshit ass agreement, the defense says they held back a lot. They said they did not cross-examine student witnesses about statements that Austin was aggressive, triggered, passionate, did not tolerate disrespect, or had a history of putting his motherfucking hands on people. Okay? Howard lists examples like Austin being kind of like the aggressive guy on the team, getting triggered, and people saying Austin and Hunter were not going to let someone disrespect them. They also said they did not call witness familiar with Austin and Hunter's alleged reputation for violence and bullying people. Did not question teachers about Austin and Hunter's school disciplinary history because they was bad as fuck, and did not elicit testimonies about an alleged arrest for racist graffiti. Them two motherfuckers wrote some racist graffitis and got arrested, y'all. They got arrested for doing some racist graffiti, okay? All of that was left out, okay? They also said they did not call certain experts, including a neuropsychologist, I can't say that word, about Karmelo's epilepsy. So the the psychologist, Lord of more, a neuropsychologist. So they did not call a neuropsychologist about Karmelo's epilepsy and perception of the threat, and a forensic psychologist about the adolescent brain development and the fight or flight response. So what did the defense give up? They gave up witnesses that these boys were bullies. They gave up an criminal record of Austin and Hunter of racist graffiti. They gave up teachers' disciplinary history on the boys. They gave up expert testimonies of a neuropsychologist and a forensic psychologist, one about his perception of a threat and the other one about how an adolescent's brain developed. Okay. So they gave up a lot. The defense gave up a lot. So what the state supposedly gave up, y'all? The state supposedly gave up using a 75-page notice of the bad act character extraneous evidence against Karmelo. But the defense point is this: the state did not really lose anything if Karmelo never testified because the door never opened. Meanwhile, the defense lost its client's testimony and did not use damning evidence against the Austin and the Hunter boys. That is the heart of this argument. Let's talk about why it matters. The defense is trying to show that, yeah, there was an agreement in place. The defense relied on this agreement. The state changed its position after the defense could no longer undo its strategy. Damn, they fucked them real good. They changed their position after the defense could no longer undo its strategy. That change scared and prevented Karmelo Anthony from testifying in his own defense case. Karmelo's testimony was critical because this is a self-defense case against himself. The state conducted a punishment confirms the agreement existed. This is why they are asking for an evidentiary hearing. The motion says the agreement, reliance, and the repudiation are disputed facts that can only be resolved through testimony. How strong is this evidence? Well, it says, I would call it potentially strong, but not complete yet. It is strong because the defense has a sworn affidavit from the trial counsel. The affidavit gives dates, names, meeting, and details. It also points to the conduct that allegedly confirmed the agreement. The state resting at punishment without using a 75-page notice. But it is incomplete because the agreement was allegedly not written down. It was done in the judge's fucking chamber. It was not recited in the open courts, not on camera. It was not put on record at all. So this is the weak spot. The defense needs testimony from the trial counsel, maybe the prosecutor, and possibly others who were present. So the 75-page notice was the state list of bad acts and character evidence against Karmelo Anthony. The defense says that both sides agreed not to use that kind of evidence. The problem is when Karmelo was about to testify in his own case, the state allegedly said the agreement did not protect him. It did not protect him. So Karmelo stayed off the stand. And then at punishment, the state did not use that 75-page against him. Ooh, baby. Ooh, baby. Ooh, baby. So the Metcalf boys got some racism in them, honey. We already knew that anyway, though. But they were arrested. They have a criminal record for some racial graffiti that they got arrested for. I don't know what they did. It didn't actually go into it, but I'm pretty sure we probably will hear about it later. So because of that, they had something over Karmelo Anthony's head and they held that, and then they pulled a plug at the last minute and said, wait a minute. I know what we said. I know what we agreed to, but that does not protect you under your testimony. So throughout the whole trial, none of your behavior was displayed as long as Austin and Hunter behavior wasn't displayed. But if you testify, we bringing up all this shit on your ass. We bringing up all this shit on your ass if you testify. So he said, nah, that's okay. I ain't gonna testify. I'm good. They fucked them. Anyway, let's continue, y'all. Let's continue. So, defendant motion for new trial. It says, After the verdict, the seal file, the missing record. Okay, ooh, let's go up to the seal file after the verdict, baby. Because, honey, you can't find shit on this shit. They seal that down. All right, let's get to the after the verdict. Let's get to after the verdict. Okay, after the verdict. The defense says secrecy continued even after the damn verdict. Trial counsel withdrew June the 10th. Appellate counsel changed, and current counsel came in June the 23rd. Meanwhile, the reporter's record was not transcribed, and the pleading case files were allegedly held in chambers instead of the public district clerk court records. What do you mean the reporter's records was not transcribed? Okay, they also said the judge gave a televised interview after sentencing defending the restriction and saying that he thought maybe he should have streamed audio but did not because people would distort what happened. Okay? It says, ooh, let me get a little bit more information on that one because what do they mean the secrecy outlasts the verdict? Trial counsel withdrew on June the 10th, so he was gone day after the damn, he lost the damn case. Appointed appellate counsel was then replaced and presented counsel were submitted June 23rd, all while the 30-day deadline for his motion ran. The reporter's record remained wholly unsubscribed. They did not unsubscribe. I mean, they did not subscribe the reporter's record. And the pleading and case file sat in the court chambers rather than in the district clerk public records, sealed by an oral order. That's crazy. Let me see how, hold on. It says this was a nationally watched murder trial, but the defense claims the public could barely get in. The overflow room disappeared once testimony started. Important pretrial matters happened off the record, and allegedly evidence agreements fell apart at the end of the trial. Karmelo did not testify because of that, and the trial moved extremely fast. And after the verdict, the file and the transcripts were not readily available when the new trial deadline was running. That is the defense factual setup for why they say the conviction should be thrown out and a new trial granted. Ooh. Okay. So let's continue. All right. So that's what they're trying to say. It went too fast. All right. It went too fast. Now, let me see. Do I want to go on into... It did go fast. This is just all saying that it went fast. The motion was timely under the Texas rule because sentence was imposed in open court on June the 9th. The 30-day had... Okay, they're just talking about the time. Okay, let's talk about the first grounds for new trial. The trial court violated defendant's Sixth Amendment right. Oh, this is just the background of it. This is just all the background of what happened. This one is argument. The first ground for new trial. The trial court violated defendant's Sixth Amendment's right to a public trial by materially restricting public access to the trial proceeding without the finding. So this is, they put all the references and things in there. This is what they're talking about. An open courtroom belongs to the people of Texas who funded it and sustained it. And I heard people out there actually talking about that. Okay, so is this it? Hold on, let me ask. So is this the gist of the motion? Because we may have finished it, but we're going to go over these. We're going to go over these exhibits. Yep, it said this is the gist of the motion. But the defense is basically saying, this is what the defense is basically saying. There was an alleged agreement. Okay, I got all that. No, I'm talking about all four arguments. Hold on. Yeah, so that's it. The public was blocked from meaningfully watching the trial, and that can be structural area requiring a new trial. This is the strongest argument. Number two, the defense says they kept their end of the deal, but the state pulled back when it mattered the most, right before Karmelo could testify in his defense, and that gutted the self-defense claim. This argument is powerful, but it needs evidence. Okay, so I need an evidentiary hearing because the agreement was allegedly off the record. How you make an agreement off the record? And then the next one, bad jury instructions. The judge gave the jury a legal reason to reject self-defense for Karmelo Anthony, even though the defense says the evidence did not support those instructions. This is probably the second strongest argument, especially because self-defense was the whole entire case. And number four is a cumulative error, interest of justice. So the gist is, even if each issue alone does not win, the whole trial process was unfair when you put everything together. So the defense has four arguments. One, the public was kept out of the public trial. Two, the state allegedly broke a basic clean trial agreement after the defense relied on it. Number three, the jury got a provocation instructions that may have unfairly weakened self-defense. And four, even if none of those alone is enough, all of it together denied Karmelo Anthony a fair trial. So it says, yes, this is the gist of the whole motion. The defense is not mainly saying the jury made the wrong emotional choice. They are saying the process was constitutionally flawed, from the public access to evidence agreements to the jury instructions. Is this powerful enough for a new trial? What is the likelihood? All right, let's see. Yes, it is powerful enough to seriously support a request for a new trial, especially on appeal. But powerful enough does not mean automatically granted, especially by the same trial court. My realistic read, the trial court likelihood at the trial court level, I would call the chances low to moderate. Why? Because a motion for new trial asks the trial court to basically say, my trial had serious errors. The judge do not often grant that in a high profile murder case, especially when the strongest claim involved the judge's own courtroom management decision. So if you ask me, will the trial judge just grant a new trial? I would not bet heavily on that, because Judge Roach is not going to come out here and say he did it wrong. It says, but I do think the defense has enough to force a serious hearing, especially because some of the issues happen off the record and needs testimony. Appeal likelihood. On appeal, this gets stronger. The defense has at least two very serious appellate issues. Public trial issue. This is the strongest one. If the appellate court agrees the courtroom was materially closed off, public access was wrongly restricted, the defense argued that it is structural error. That is powerful because structural error does not require the defendant to prove the verdict would have changed. The motion argues the closure affects jury selection, guilt, innocence, and punishment. So the remedy should be a complete new trial. This is a big deal. Number two, the provocation jury instruction. This is also strong. Self-defense was the entire defense. If the jury got a provocation instruction that was not supported by evidence, that could be harmful because it gave jury a path to reject self-defense. The defense says there was no evidence Karmelo Anthony had a preformed plan to provoke Austin Metcalf so he could kill him. And the state used that instructions during their closing. That could absolutely matter on appeal. The agreement issue is powerful, but harder to prove. The alleged clean trial handshake agreement done in the judge's quotas in his chambers is emotionally powerful and could matter a lot, but it is harder because it was allegedly not put in writing or on the record. The defense will need testimony to prove that it existed, prove the terms, prove reliance, and prove the state backed away too late. The motion itself says this issue needs an evidentiary hearing because the facts cannot be resolved from just the current record. Man, they did some shady shit in the judge chambers outside of any witnesses like the damn news people or anybody else, court reporters and all that shit. They did a handshake that they did not stick to, okay? So that issue is not weak. It's just more fact dependent. Okay. Now, for a new trial granted by the trial judge, maybe only a 25 to 35%. For the defense to at least get a serious evidentiary hearing, that's 60 to 75%. For these issues to give Karmelo Anthony a meaningful shot on appeal, I would say high, maybe 50 to 65%, that at least one issue gets serious traction depending on the full reporter record. For an actual appellate review or appellate reversal new trial, I would say moderate, maybe 35 to 50%, with the public trial issue being the strongest path. So, yes, the motion is powerful. It is not just complaining about the verdict. It attacks the trial process itself, public access, the alleged evidence agreement, Karmelo's right to testify, and the jury instructions that limited self-defense. The strongest argument is the public trial violation because if the appellate court agrees, that can be structural error and could mean a full new trial without proving the jury would have ruled differently. So I would not say he is definitely getting a new trial, but I would say this is a serious motion with real appellate teeth, and the states should be concerned. Hold on, let me ask. Will the state get an opportunity to reply, or will the judge just say no? Can a judge just rule and say, no, we don't want a new trial? And then what's the next steps? Judge Roach is not going to give him a new trial. Hold on. It says, yes, the state would normally get an opportunity to respond, but the judge does not have to wait forever. And if the judge does nothing, the motion can die by the deadline. Wait a minute, what? Wait a minute, what? The motion can die by the deadline. The state can file a written response. The prosecutor can file a response arguing why the motion should be denied. They would likely say the courtroom was not closed because some public seats were available. The defense did not object in time. The clean trial agreement was not enforceable or did not cover Karmelo's testimony. The provocation instructions were supported by evidence, and any error was harmless. So yes, the state can respond. They can also argue against an evidentiary hearing. The judge can grant a hearing or deny without one. Or deny without one. The defense is asking for the evidentiary hearing because some facts are outside the trial's record, especially the alleged agreement and public access issue. The motion says this matters cannot be determined from the current record and may require testimony from trial counsel and possibly the prosecutor. But the judge can still say, I'm denying this motion or I'm denying a hearing. And if the judge does that, the defense can argue on appeal that the judge abused his discretion by refusing a hearing on fact issues that needed testimony. But can the judge say no? Yes, a judge can sign an order denying the motion for a new trial. The judge could say, motion denied, evidentiary hearing denied, new trial denied. That does not mean the case is over. It just means the issue moves into the appellate phase. What if the judge does nothing? If the judge does not rule in time, the motion can be overturned by operation of law, meaning it is denied automatically because the deadline passed. So in this case, the defendant says the sentence was imposed on June the 9th of 2026. The motion was timely, and the court has authority to rule through the 75th day after sentencing. They specifically request a hearing and ruling by Friday, August the 21st of 2021, because the 75th day falls on Sunday, August the 23rd, 2026. So if no ruling happens by that deadline, it is basically treated as denied, which means if the judge does nothing, today is July the 9th, if the judge don't do nothing until that date of August the 21st of 2026, it is automatically denied. Okay. Now, what happens after denial? Then the appeal continues. Karmelo already filed a notice of appeal, and the case was docket in the Fifth Courts of Appeal. So the appellate record gets approved. Next steps would be the appellate records get approved. That includes the clerk's record and reporter's records transcripts. The defense files its appellate brief. The state files its response brief. The defense may file a reply. The Court of Appeals review the legal issues. They can affirm the conviction, reverse for a new trial, reverse for a new punishment hearing, or send something back to the trial court if needed. So the states will likely get to answer his motion, and the judge can either set a hearing, deny it outright, grant a new trial, or let it be denied by the deadline, which is August the 21st of 2006. Okay. Now, if the judge says no, that is not the end. It just pushes it to the push the fight to the Fifth Courts of Appeal, where the public trial, right to testify, and jury instruction issue become an appellate issue. Now, let me ask you a question. This is a request for a new trial. What about appealing the verdict, the sentence? Yeah, what about that and the jury selection? Like, are we going to hear any of that? So I'm trying to, is this their only fight? I know it can't be. Or are they saying this is enough? Let's see. All right, until that come up, let's look at some of these exhibits, y'all. What are y'all thinking? Let me get some of y'all. Okay, so it says, but Mike Howard and Toby Shook being parties to the agreement is the proof. That's why Howard provided an affidavit. Yeah, but it wasn't in writing, though. They didn't get it in writing. The proof is Mike Howard's affidavit. The jury instructions and public access are the biggest issue of the appeal. Let me ask something right quick. Is the affidavit of Mike Howard enough to prove that there was an agreement put in place? It says the affidavit of Mike Howard is enough to raise the issue and justify an evidentiary hearing, but by itself, it may not be enough to automatically prove the agreement and win a new trial. Enough for a hearing? Yes. Mike Howard was the trial counsel. He is the person with firsthand knowledge of the conversation, the alleged agreement, the reliance, and what happened when Karmelo was deciding whether to testify or not. The motion says the agreement was never reduced in writing or put on the record. So the defense is relying on Howard's affidavit and asking for a hearing where the trial canceled and possibly the prosecutor can testify. That is exactly what an affidavit is used for in a motion for a new trial, to show there are facts outside of the trial record that the court needs to hear evidence on. So yes, Howard affidavit is likely enough to get the court's attention and to argue for a hearing. Enough to prove the agreement by itself? Maybe, but that's harder. An affidavit is a sworn evidence, so it does matter. But because the alleged agreement was not written down, not announced in the open courts, not put into an order, and not recorded by any court reporter, the state will likely argue this is just the defense version of what happened. The motion itself admits this is a disputed fact issue and says the existing terms and refutation of the understanding needed to be resolved at evidentiary hearing. That means the affidavit is not the finish line, it's more like the door opener. What would make it stronger? Howard's affidavit becomes much stronger if other evidence back it up, such as testimony from another defense lawyer who was present at the time, any emails, text message mentioning this agreement, a motion in limine that reflects this agreement, or the state's conduct at punishment. So the prosecutor testimony is confirming part of it. The judge or court staff remembering the May 21 in chamber discussion, and the defense already argued that the state owns conduct helped prove the agreement because at the punishment, the state called no witnesses and did not use that 75-page notice exactly how Howard says the prosecutor described the agreement would operate. So that is circumstantial evidence. It does not prove everything by itself, but it does support Howard's affidavit. So bottom line, yes, Mike Howard affidavit is enough to support the claim and ask for a hearing, but no, I would not say it automatically proved the agreement beyond the dispute. So it is powerful because he was the trial lawyer at the time and he is swearing under oath that this agreement exists. But because the agreement was never put on record, the court will likely need an evidentiary hearing. The affidavit opens the door. Testimony and collaborating evidence would have to prove it. So the state can come back and say that shit didn't happen, or it did not happen like that, or we did not agree to it that way. However, based on some of the things that did not take place, and that is bringing up 75 pages of Karmelo Anthony's behavior, is also proof that they had that discussion. She said, read Exhibit 10. Okay, that's what I was going to do, actually. Let's get to Exhibit 10. Exhibit 10. All right. Affidavit of trial counsel Mike Howard signed and notarized. Before me, the undersigned notary public on this day personally appeared Mike Howard, who being by me duly sworn, deposed and stated as follows. I, Mike Howard, am at least 18 years of age, of sound mind, and I am competent and qualified to make this affidavit. I have personal knowledge of the facts stated herein, and that they are true and correct. I declare that I was the trial counsel. I was a trial counsel supported by second chair co-counsel Toby Shook, third chair and co-counsel Tasha Gupta, and briefing appellate co-counsel Michael Maula, who represented Karmelo Anthony in case number 296-835-652025, leading up to the July 1st, 2026 trial of this case. The defense and the prosecutor reached an agreement where the prosecutor and the defense jointly agreed to not raise any alleged character, reputation, or extraneous offense, bad acts, evidence relating to Mr. Anthony, as well as Austin Metcalf and Hunter Metcalf during the trial, hereafter referred to as the agreement. The lead prosecutor in the case, Bill Worski, brought up the possibility of the agreement a number of times well before the agreement was discussed in details and eventually reached. So that tells me that Bill, the prosecutor, is the one that asked for it. He brought it up, the possibility of the agreement. So he wanted their behavior to be kept out of the court if he's the one bringing it up. Anyway, it says, when mentioning a proposed agreement, Mr. Worski proposed that we try the case clean, which is defined as based only on what happened under the tent that day, under the Memorial High School tent at Q Kendall Stadium on April the 2nd, 2025, and not go into character, reputation, or extraneous offenses and or bad acts, evidence applicable to either Austin and Hunter Metcalf or Karmelo Anthony. So on May the 5th of 2026, Mr. Shook and Mr. Worski discussed this proposed agreement by the phone. During that phone call, Mr. Shook and Mr. Worski discussed the evidence of character, reputation, and extraneous offense, bad conducts as it applied to both the Metcalf twins and Karmelo Anthony. So Mr. Worski reiterated that he would be happy to try this without getting into character at all, just on what happened that day on the track meet. On May the 8th of 2026, the defense and the prosecutor's teams met in the Collins County grand jury room. The prosecution team gave us a document entitled State's Notice of Intent to Use Extraneous Offense. Hereafter, state notice, and we gave to them a document entitled Anthony's Motion in Limine regarding the admissible pertinent character trait evidence. Evidence under the ambiguous aggressor rule. The evidence under Texas Code Criminal Proc Art 38.6. Hereafter defense notice. After tendering to each other our respective extraneous filing briefing, we then discussed the proposed agreement, which Mr. Worski referred to as a gentleman's agreement. Mr. Worski outlined the proposed agreement as follows. Both sides try the case without character, reputation, or extraneous evidence for either the Metcalf twins or Karmelo Anthony, and just try the case based on what happened under the tent. And during another description, during that meeting, what happened on that day of the incident. Seeking clarification, I asked, and Mr. Worski confirmed that this would mean that the defense would not go into evidence relating to the Metcalf twins' character, reputation, and extraneous offenses related to violence and bullying, inclusive of discipline and write-ups in the Metcalf twins, school records within this framework, as well as racism. In exchange, the prosecutor would not go into the character, reputation, and extraneous offenses or acts, evidence relating to Karmelo Anthony, inclusive of the content of Karmelo Anthony's cell phone and the school disciplinary records. At this meeting, I sought clarification of how this agreement would work practically, specifically how to handle the possibility of the opening the door to this evidence from either side. During this meeting, Mr. Worski repeatedly expressed his concern that the defense would kick open its own door by asking questions of witnesses that would delve into issues restricted by the agreement. I asked about specific statements made by the witness interviewed by the police and captured by video. On the day of the incident, those witnesses discussed the Metcalf twins being passionate, triggered, and not tolerating being disrespected. E.T. Citra, Mr. Worski eventually agreed that the questioning narrowly tailored to ask about specific statements the witness made to police about the incidents under the tent on April the 2nd, 2025, including statement just described about the mindset and actions of the parties, including in the incident, would not constitute kicking open your own door and thus would not violate or propose agreement. During this meeting, we discussed the terms of the agreement, being that testimony from eyewitness from under the memorial tent on April the 2nd, 2025, and who were discussing the facts of what happened under that memorial tent on April the 2nd would be permissible, and that neither side would go into character, reputation, or extraneous evidence for either the Metcalf twins or Karmelo Anthony. During this meeting, I also asked about the agreement regarding the possibility of the defense calling expert. The prosecutor only discussed how the agreement would apply to defense experts during the sentencing phase. So I asked how the possibility of the defense calling expert to testify during the guilt innocent phase would impact the proposed agreement. The prosecutor team replied that they had not considered us calling experts to testify during the guilt innocent phase. They stated that if the defense called experts to testify regarding Mr. Anthony's epilepsy or about a fight or flight response, they consider expert testimonies like that to violate the agreement and thus open the door to character, reputation, and extraneous offense acts evidence. Man, let me tell you what they did. They played the defense. I thought this was an experienced attorney. They played in their faces. They played them. Straight up ass played him. Anyway, on May the 11th, 2026, Mr. Worski, Deewoo Mitchell, Mr. Shook, and I discussed the proposed agreement again by phone. I informed the prosecutor that we had an informal agreement on the proposed agreement, but that we needed to have a final conversation with Mr. Anthony and his parents to confirm the final agreement. During this phone conversation, Mr. Worski confirmed that the agreement would extend to the sentencing phase of the trial as well. Mr. Worski said that would mean that in accordance with the agreement, the prosecutor would quickly rest its sentencing case in chief without going into any of the allegations listed in the state's notice. Mr. Worski said, however, that he would not allow a false impression to be presented to the jury by a defense witness, and that if such a thing occurred, he would respond by going into character, reputation, and extraneous evidence from the state's notice. After the defense asked about Anthony's family member testifying at sentencing, Mr. Worski agreed that the agreement would cover Mr. Anthony's mother's testifying to the standard, "I love my son, please show him mercy" type testimony, but no further. What? Are you fucking kidding me? Hold on, y'all. This is so, I ain't never heard of no shit like this in my life. She couldn't even say, "Oh, I got a good son and he's this and he's that." What the fuck? Hold on, y'all. Wait a minute. I ain't finished, but I got to pause for the mother effing calls because this shit right here is blowing me. Can you go further into this? Oh, Lord, honey, let me break this all the way down. What I just read right here. Okay. It sounds like the defense and the parents got played, and Karmelo got played like a fiddle faddle. Ooh, this is long. I said, go into it in detail and break this down for me, honey. Y'all listen up, child. I'm going to need y'all to turn your volume up, baby, because we about to hear what this is all about. Hold on. Give me a second, baby.
Yes, this paragraph is very important, and I understand why it concerns you. This is basically describing an alleged off-the-record / informal agreement between the defense and the prosecution about what the state would and would not do during punishment sentencing. Here's the breakdown. What the defense says happened. The affidavit says that on May 11, 2026, the defense lawyers and prosecutors had another phone call about a proposed agreement. The defense lawyer says he told the prosecution, open quote, "We have an informal agreement, but we still need to speak with Karmelo Anthony and his parents to confirm the final agreement." Close quote. That matters because the lawyer is saying this was not just casual conversation. They were discussing a real trial agreement that affected strategy. The key part, the agreement extended to punishment. This line is the big one, open quote. Mr. Worski confirmed that the agreement would extend to the sentencing phase of trial as well. Close quote. That means the defense claims the prosecutor agreed that this deal was not only about the guilt-innocence phase, it would also cover punishment. So if the jury found him guilty, the state would supposedly not use the 75-page notice of allegation / extraneous conduct character evidence during sentencing unless the defense opened the door. That is major because sentencing is where the state can sometimes bring in damaging information to argue for a harsher sentence. What the state allegedly promised to do. The paragraph says the prosecutor said the state would, open quote, quickly rest its sentencing case in chief without going into any of the allegations listed in the state's notice. Close quote. In plain English, the defense says the state agreed that during punishment, They would basically stand up, present little or nothing extra, and rest, instead of putting on witnesses or evidence about Austin's behavior, character, alleged bad acts, or other damaging punishment evidence. That could absolutely affect how the defense prepared for trial. But there was a warning: don't create a false impression. This part is also important. Open quote: he would not allow a false impression to be presented to the jury by a defense witness. Close quote. That means the prosecutor allegedly said, we won't bring up all this bad character, extraneous evidence first, but if the defense puts on a witness who makes Karmelo look falsely perfect, then we are going to respond. For example, if a defense witness got up and said something broad like, he has never been violent, he has always been peaceful, he would never hurt anyone, he has no bad history, he is an angel, then the state could argue the defense opened the door and the prosecution could bring in character, reputation, or extraneous offense evidence from that 75-page notice to rebut it. So the agreement was conditional. Why the mother's testimony matters. The paragraph says the defense specifically asked about Karmelo's mother testifying at sentencing. The prosecutor allegedly agreed that the agreement would cover her testifying only to a very limited type of testimony. Open quote. I love my son, please show him mercy type testimony. Close quote. That means the mom could speak emotionally as a mother, asking for mercy without opening the door, as long as she did not go further. So she could say things like, my son is loved, please show him mercy. Our family is devastated. I am asking the jury not to give him the maximum. But she likely could not go into broader character claims like, he has never been in trouble. He is not violent. He is a good kid who would never do this. He has always made good choices. Because that could trigger the state's right to bring up the damaging allegations in the 75-page notice. Why this is concerning? This is concerning because if the defense believed the state had agreed not to use the 75-page punishment evidence, that could have shaped major decisions, including whether Karmelo testified, whether his mother testified, what mitigation evidence they presented, how they prepared for punishment, and whether they were less aggressive in preparing to fight the state's punishment evidence. The defense is basically saying, we relied on this agreement. The state did exactly what they said they would do by quickly resting at punishment. That proves the agreement existed. But the jury and/or court may not have known the full context of why punishment unfolded that way. Does this prove there was an agreement? It helps. But by itself, it is still one side's sworn version unless there is more supporting evidence. It becomes stronger if there are texts, emails, call records, notes from both sides, another affidavit from another lawyer on the call, statements from the prosecutor confirming part of it, or the actual sentencing behavior matching the agreement. And according to this paragraph, the state's later conduct, resting quickly and not using the 75-page notice, does seem to match what the defense says was agreed to. That is why the defense is pointing to it. The biggest issue legally, the big question is not just, was there an agreement? The bigger legal question is, did this agreement affect Karmelo's rights, trial strategy, punishment strategy, or ability to make informed decisions? For a new trial, the defense usually needs to show more than there was a misunderstanding. They need to show this mattered in a way that may have harmed the defendant or undermined confidence in the outcome. So yes, this paragraph is important. It suggests the defense is trying to prove there was a real or relied upon agreement that controlled how punishment would be handled, especially regarding that 75-page notice.
Damn. Can you look at Exhibit 10 and break it down paragraph, or should I say from number to number, Exhibit 10? This is crazy. They even set up the mama. Damn, the mama couldn't even say. So then what about, man, I would have said, tell it all. What the fuck did Karmelo have in his phone that they was so afraid of being? I would have been like, I don't give a flying patch face. Tell it. Because once the jury heard about the racism and all that other bullshit that the Austin boys, them being damn bullies and shit like that, then, I would have been like, tell him, my son ain't no damn monster. Tell that shit. 1 or 2 incidents or something like that. Like, what the fuck? Oh, my goodness. When I tell you, I would have said, put it on the floor. Okay, we're going to break down the whole number 10. Hold on. Give me a second. We're going to break down the whole thing. All right, here we go. Ooh, this long as hell. Damn. Is it that long? We all the way down to damn 30. Oh, it is. It is long. Y'all ready for exhibit number 10? Ooh, baby. Ooh, baby. It's all right. It's all right. It's all right. This is crazy, y'all. We about to break this whole thing down. Now, y'all know when it starts, it goes straight through, okay? So we're going to break down number 10 all the way down to the real nitty gritty. If you need to go run and get something to drink right quick, go ahead, run and get something to drink and come right back, okay? Let me know when you're back. Let me know when you're back because I need 5 backs. I'm back. And we're going to get down. We're going to break down exhibit number 10 all the way down. This affidavit from Mike Howard all the way down. He was the trial judge. Trial lawyer at the time, attorney. I would have told them, say whatever my son did because we're going to talk about these bullies. You hear me? Oh my God, man. I don't know if I would have agreed to that. I need 5, I'm back. So at least 1 or 2. If you left and came back, let me know. Get you something to drink. I'll wait 30 more seconds. She said, this isn't a mother effing conspiracy. This is what they did to him. Yeah, it sounds like the prosecutor was way smarter than the defense attorney. Because it sounds like they played him like a fiddle faddle. It sounds like they played him like a fiddle faddle. She said, I went and got watermelon. I'm back. Okay, I'm back. All right. So let's play it, y'all. Y'all know it goes all the way through, okay? All the way through. But it's long. Here we go.
Yes. Exhibit 10 is the sworn affidavit of trial counsel Mike Howard. It has 30 numbered paragraphs, and it is one of the most important exhibits because it lays out the defense's version of the alleged try the case clean agreement, how the defense says it relied on it, how the agreement allegedly broke down, and how that affected Karmelo Anthony's decision not to testify. The exhibit is identified in the motion as Affidavit of Trial Counsel Mike Howard, or by number. Paragraphs 1 to 4, who Mike Howard is and how the agreement started. Number 1, Mike Howard says he is competent to make the affidavit and that the facts are based on his personal knowledge. Number 2, he says he was trial counsel for Karmelo Anthony, supported by other defense lawyers. Then he introduces the central issue. Before trial, the defense and prosecution allegedly reached an agreement that neither side would bring up character, reputation, extraneous offenses, or bad acts about Karmelo, Austin Metcalf, or Hunter Metcalf during trial. Number 3, Howard says laid up the agreement several times before it was finalized. The phrase used was basically, try the case clean. Howard says Worski defined that as focusing only on what happened under the tent that day, not going into outside character bad act evidence. Number 4, Howard says that on May 5th, Toby Shook and Worski allegedly said he would be happy to try the case without getting into character at all. Just what happened at the track meet. Why this matters. This is where the defense is trying to show the agreement was T. They are saying it started before trial and came from the prosecution. Paragraph 5, the May 8th meeting and the gentleman's agreement, number 5. This is a big one. Howard says on May 8th, the defense and prosecution met in the Collin County grand jury room. The state gave the defense its notice of intent to use extraneous offenses, and the defense gave the state its own motion in Lamine about character evidence, ambiguous aggressor evidence, and Article 3836 evidence. Then, according to Howard, Worski called the proposed deal a gentleman's agreement. The alleged deal was, The defense would not go into the Metcalf twins' character, reputation, violence, bullying, discipline, school records, or racism evidence. In exchange, the prosecution would not go into Karmelo Anthony's character, reputation, phone contents, school disciplinary records, or extraneous bad acts. Howard says they also discussed what would or would not open the door. Specific witness statements about the incident, like Austin being passionate, triggered, or not tolerating disrespect, were allegedly allowed as long as they were tied to what happened under the tent. Why this matters? This paragraph explains the trade-off. The defense is saying, we gave up damaging Evi in exchange for the state not using damaging evidence against Karmelo. That is very important because the defense is claiming they changed their whole trial strategy based on that bargain. Paragraph 6, the sentencing agreement number 6. This is the paragraph you showed me. Howard says on May 11, he, Shook Worski, and Dewey Mitchell discussed the agreement again by phone. Howard says he told the prosecution they had an informal agreement, but still needed a final conversation with Karmelo and his parents. He says Worski confirmed the agreement would also apply to the sentencing phase. According to Howard, that meant the state would quickly rest its punishment case without going into the allegations listed in the state's notice. But Worski allegedly warned that if the defense created a false impression through a defense witness, he would respond with character, reputation, and extraneous evidence.
He called it bluff.
Then Howard says they specifically discussed Karmelo's mother testifying. Worski allegedly agreed she could give limited testimony like, I love my son, please show him mercy, but not more than that. Why this matters? This means the alleged agreement did not just affect guilt-innocence. It also affected punishment. The defense is saying in case because they believe the state would not unleash that 75-page notice unless the defense opened the door. That is why this paragraph is concerning. Paragraph 7, the agreement was allegedly told to the judge number 7. Howard says on May 21st, both sides met with Judge Roach in chambers. According to Howard, both sides explained the agreement to the judge as an agreement not to go into character, reputation, or extraneous evidence during both guilt, innocence, and sentencing, unless a door was opened or false impression was created. Howard says they agreed the best way to document it was through a motion in Lehman that would be generic enough not to cause media reporting about bad act evidence. He says he drafted that motion and sent it to Worski, and it was hand-delivered to the judge on the first day of trial. Why this matters? This is huge because the defense is saying the judge knew about the agreement, but it was allegedly discussed in chambers and not put on the poo.
Not put in the public.
Paragraphs 8 to 12. The defense says Karmelo's own testimony was covered. Number 8. Howard says the defense understood the agreement to cover all witnesses who could testify about what happened under the tent, including Karmelo Anthony. He says because Karmelo was an eyewitness to the incident, the defense believed he could testify about what happened without opening the door to character or extraneous evidence. Number 9. Howard says the understanding was confirmed by later events. He describes a May 29th discussion about trial security and timing. He says he raised concerns that if the state rested early, they're Milo out of order because other witnesses were unavailable. Number 10. On June 5th, Howard says he again told...
Let me stop. It's skipping stuff. Let me go back up to where it says... hold on. I think I was on number 8. No, I was on number... Yeah, let's start with number 8, okay? It says, okay, y'all, I'm going to read it because my AI is skipping. It says, Howard says the defense understood the agreement to cover all witnesses who could testify about what happened under that tent, including Karmelo Anthony. He says, because Karmelo Anthony was an eyewitness to the incident, the defense believed he could testify about what happened without opening the doors to character or extraneous evidence. Number 9, it says, Howard says the understanding was confirmed by later events. He described a May 29th discussion about the trial security and the timing. He says he raised concern that if the state rests early, the defense may have to call Karmelo out of order because other witnesses were unavailable. Number 10, it says on June the 5th, Howard says he again told Worski, which is the prosecutor, that Karmelo might have to be called out of order if the state finished early. Howard says he was clear that the defense intended to call Karmelo to testify. So he's saying Karmelo was supposed to testify and the prosecutor knew that. All right. Then it says, number 11. Hold on. Let me not skip. Howard says on June the 6th, he and Shook repeatedly checked in with the prosecutor about timing and kept referencing the possibility that the court schedule would force them to call Karmelo out of order. Number 12. This is one of the strongest defense paragraphs. Howard says Worski knew the defense intended to call Karmelo. He also said the whole point of this agreement from the defense perspective was to allow Karmelo Anthony to testify about self-defense without being impeached by character, reputation, or extraneous bad acts evidence. Why does this matter? This is the heart of this dispute. The defense said, we always understood that Karmelo Anthony was testifying, his testimony would be covered. But later, according to Mike Howard, the prosecutor said, no, the agreement never contemplated a testimony from Karmelo Anthony. That conflict is major, okay? So right there, the prosecutor is saying, nope, I didn't know you was going to call Karmelo Anthony. And the defense attorney saying, yes, you did. And we reminded you over and over and over. You knew my client planned to take the stand, all right? So then let's go on to number 13. It says how the defense says it relied on the agreement. Howard said the defense changed its trial strategy because of this agreement. And without the agreement, they intended to cross-examine memorial student witnesses about Austin and Hunter alleged character for violence, bullying, and racism. Okay? It says, however, number 14, Howard lists examples of statements the defense said it could have used, such as Austin being described as aggressive, triggered, passionate, or someone who did not tolerate disrespect. These are the things that was said to the popo. All right. So they knew this, right? Now, why is this concerning? It's concerning because, hold on, I just skipped. Oh, Lord, I ain't mean to do that. Let's go back up. I'm sorry. Howard lists examples of statements the defense said it could have used, such as Austin being described as aggressive, triggered, passionate, or someone who did not tolerate disrespect. Number 15, Howard says if the prosecution did not call certain witnesses, the defense was ready to call them as hostile witnesses. He also says the defense intended to call witnesses about Metcalf twins' reputation for being violent, being bullies, victim of alleged violent bullying, teachers about school disciplinary history, and evidence about alleged racist graffiti. All right, let me see. Racist graffiti. And then it says, Howard says the defense did none of that because it relied solely on this agreement. He also says the defense decided not to call experts, including the neuropsychologist and the forensic psychologist, because the prosecutor allegedly said the psychologist related testimony would open the door to character and extraneous evidence against Karmelo. Okay, so basically the prosecutor scared them into silence. Okay, said that if you get a psychologist to come up there and say how he was feeling or his mental state at that time, then they will bring up past things that Karmelo may have done or things that he had in his phone that could have hurt his credibility. Okay, now that was number 15. So, that was number 16. Number 17, Howard says because of the agreement, The defense did not go into these subjects during the voir dire or opening statement. He says if there had not been no agreement or the defense knew the states would later back away from what they agreed to, they would have handled the jury selection and the opening different. What the fuck? You relied on agreement or whatever, so you screwed your client because you basically shook dirty hands with a dirty ass prosecutor. And when the prosecutor backtracked on your ass and backslid on your ass, Karmelo Anthony was left hung to dry. Okay. So number 17, it says, Howard says, because of the agreement, the defense did not go into these subjects. Oh, I just read that one. Number 18, Howard says the defense also relied on the agreement during sentencing. They did not designate a mitigation expert and severely limit Karmelo's mother testimony to just 3 questions. He also says the defense avoided going into substantial family violence Karmelo had allegedly witnessed or experienced. Okay. Oh, shit. Wait a minute. What are you trying to say? Are you trying to say that Karmelo Anthony has seen some shit? Apparently so. So it said, why this matter? This is where they try to prove harm or prejudice. The defense is saying this agreement caused them to give up evidence, witness, and expert testimony, cross-examination, voir dire themes, opening statement themes, and mitigating evidence. This is much bigger than a simple misunderstanding. Now, number 19, it says, Howard says on June the 6th, after the state rest, the defense called several witnesses and then ended the day. Number 20, it says on June the 8th, the defense resumed. Howard says the next planned witnesses had been avoided subpoenaed, but later said he would arrive at court. Ooh, what's this one about? Hold on. That was number what? 20? On Monday, the defense resumed its case in chief, calling Brendan Stevens and Brendan Lacey, the defense next planned witness, had been avoiding the defense subpoena and kept changing the time. Okay, I just told him. All right. So then number 20, it said there appears to be a numbering issue because the affidavit has another 20 inches. In this paragraph, Howard says during a 10:50 a.m. break, the judge asked for timing updates. Howard told the court the next witness was a coach who could testify about Karmelo Anthony's seizures. Worski allegedly argued that epilepsy testimony was irrelevant and would open the door again to character, reputation, and extraneous evidence. Judge Roach apparently agreed that epilepsy evidence was not relevant at guilt, innocence, and would open that door. However, Howard says he then told the court he would not call the coach. He also told the judge he was 99% sure Karmelo would testify. So even the judge says if you have someone come up and mention anything about his epilepsy, that will open the door of his character. Okay. So they didn't even want the epilepsy mentioned again. They didn't want nobody to know that this boy dealt with epilepsy, and if even threatened to be hit, he could possibly go into a seizure, which could possibly cost him his life. Okay. But the judge even agreed with the prosecutor. The prosecutor was a bully, really. The prosecutor, like, I'm telling you, you have this expert come up here and speak on his epilepsy. We're going to show what he got in his phone. We're going to show some of the things that he's done in the past. Okay. That's what I'm telling you. They did. They held that shit over his head. Bring up your fear of threats. Bring up your fear of seizures, and we're going to open a can of whoop ass on your ass and tell them what you've done in the past. They held that over his head instead of holding all the bullshit that the damn Metcalf twins has done over their heads. Okay, they didn't do that. They held Karmelo Anthony's bullshit over his head. Number 21. Howard says that the defense called a detective instead, then broke for lunch early, and both sides stayed behind to speak with the judge outside the jury's presence. Number 22, it says this is another major paragraph. Howard says Worsley claims Howard had already opened the door by saying in the opening statement that Karmelo played chess. Howard says he did not say Karmelo was in chess club, only that he played chess as part of background. Howard says Worski also stated that from his perspective, the agreement did not cover a testifying defendant and that the prosecutor never thought the defense would call Karmelo Anthony to testify. So right here, the prosecutor is saying that this agreement didn't cover Karmelo Anthony. No. You can go and disregard all the witnesses that would have came forth and talked about Austin being a bully, Austin being a racist, Austin being aggressive and easily triggered. But now that we are on Karmelo Anthony, if Karmelo Anthony opened his mouth, we're going to release whoop ass and tell about his past. That's basically what the prosecutor presented. Okay. Then it says, Howard said Judge Roach stated that mentioning chess in the opening did not open the door, but the parties argued about whether the agreement covered Karmelo Anthony testifying. Howard said that the state repeated its position that it did not cover that, and that if Karmelo Anthony testified, his character, his reputation, and extraneous evidence would be in play. Howard says the discussion turned into a shouting match. So they shouted because the defense attorney is like, no, what the hell are you talking about? We agreed. We had an agreement, and the prosecutor says no. If he testifies, his behavior, his past offenses will be displayed. They bullied him into shutting the fuck up. Now, why does this matter? This is alleged a breach of the contract, the agreement, the gentleman handshake in the damn judge's quarters. The defense says the defense says they operated the entire trial believing Karmelo could testify under this agreement. Then right before he was expected to testify, the state allegedly said no. If he testified, we can use the bad act evidence against him. That is the moment the defense says everything changed. They pulled the rug from underneath him. Number 24, the impact on Karmelo Anthony's decision whether to testify. Howard says after the agreement was broke by the snake-ass prosecutor, both sides took 10 minutes to cool off and then tried to renegotiate how the agreement would apply if Karmelo testified. Howard said he had to preview his direct examination line by line with Worski to see what the state would claim opened the door. Howard says he had never taken such a drastic step before, but felt he had no option. Yeah, because they punked your ass is what they did. They punked you and you fell for the okie doke. Okay. So number 25, it says Howard said Worski objected to various topics in the planned testimony as the opening of the door. So Howard said he disagreed, but cut those topics anyway to try to save the agreement. He says they then told Judge Roach they had reached a renegotiated understanding about how Karmelo testimony would be handled. Howard says, number 26, Howard says before they could speak with Karmelo and his parents, Judge Roach told them he had no mechanism to enforce this agreement and that if Karmelo Anthony testified without the door being open, the judge saw no way for him to do that. So Howard said the judge indicated he will rule under the Texas rule of evidence alone. So Howard said he then had to explain all of this bullshit to Karmelo Anthony and his family. The judge gave them only 10 minutes to do so. So they discussed Karmelo's Fifth Amendment rights and whether he would testify. Howard says he asked for more time because this was a complicated decision for a 19-year-old young fella in an extremely stressful situation. But the judge declined and said, hell no, 10 minutes only. Bring your ass back in here. So number 28, Howard said the biggest issue was the risk that Worski would claim the defense had opened the door and bring in Karmelo Anthony's extraneous bad acts, character, and reputation. Howard said the defense believed that risk was too high, especially because the judge had said he could not force the agreement and would just rule under the evidence rule. Why does this matter? This is where the defense is saying Karmelo's decision not to testify was not truly voluntarily in the original sense. They are arguing he was forced into a bad choice, testifying and risk damaging bad act evidence or stay silent, even though testifying was supposedly the defense plan. They had planned all along for Karmelo Anthony to say what the fuck happened under that tent, but they had to withdraw because even the judge said, I can't save your client. I can't. No, I already know what's going to happen. So the judge already knew that Roach planned to bring out all the bullshit that he had that the prosecutor planned to bring out all the bullshit that he had on Karmelo Anthony to make him look bad, even after they had got past all the bullshit that they could have brung out on Austin and his punk ass, bully ass brother. Now, number 29, Howard says Karmelo ultimately chose not to testify. He called it a 180-degree change in the defense strategy and says it was the direct consequence of the breach of the agreement that he made with that punk-ass prosecutor, Worski. He says by the time the agreement broke down, it was just too damn late to redo. Voir dire, open statements, cross-examination, witness choices, and sentencing strategy. He says the breach significantly undermined the defense ability to present a complete defense for Karmelo Anthony, which means he failed, and he know he did, and he admitting that shit. Mike Howard, you ain't shit. You let them do this to you. They railroad your bitch ass. Number 30, it says, this is the signature portion. Mike Howard signed the affidavit, and it is notarized. Plain mother effing English. The gist of Exhibit 10 is saying the prosecutor allegedly offered a clean trial agreement off the fucking record so they couldn't trace it. But the defendant accepted it and gave up damaging evidence against Austin and his punk ass, bully ass brother Hunter. The defense believed Karmelo could still testify about what happened under the tent without opening the door. But the state allegedly later said that the agreement did not cover Karmelo Anthony's testimony. The judge allegedly said he could not force the agreement to cover Karmelo Anthony testimony. The defense had only 10 minutes to advise Karmelo Anthony and his family as to what was going on. And that took 10 minutes. He asked for more time and the judge told him no. So 10 minutes for a 19-year-old to decide. Either stand up, testify, and defend yourself and get subject to all the bullshit coming out on you, or shut the fuck up and stay silent and lose this case, get sentenced to 35 years in prison and serve 17.5. So Karmelo Anthony did not testify because he knew the prosecutor was going to bring up all the bullshit that he lied and said that he wasn't going to bring up. The defense said that changed the whole case and prevented him from presenting a complete defense case. So he failed at his duty because he let that bitch ass prosecutor Worski bully his ass. Okay. Now, why is this concerning? It is concerning because this affidavit claims the defense made major trial decisions based on an off the record agreement. If the judge believed this affidavit, the issue is not just Karmelo Anthony didn't testify. The issue becomes, did the state induce the defense to try the case one way and then change the rules after the defense had already relied on the agreement? They snaked them. This is why exhibit number 10 is so powerful, but it is also why the state will almost certainly dispute it. The judge may need an evidentiary hearing to hear from Howard, Shook, Worski bitch ass, Mitchell bitch ass, and possibly others about what actually they agreed to. This is powerful. This entire exhibit number 10 from Mike Howard and some other attorneys that was also punked by the prosecutor. This exhibit number 10 is huge. So basically, Mike Howard himself said the fact that the prosecutor pulled out at the last minute fucked him up from being able to give Karmelo Anthony a good defense. They fucked him. They fucked him, and he know it. And he knows it. Yeah. He couldn't do nothing else. His hands was tied. If Karmelo Anthony got up and testified, Worski was going to open up a can of whoop ass on him. Worski even said if you bring up epilepsy, they said epilepsy didn't have nothing to do with whether he was guilty or not. If you bring up epilepsy, we're going to bring up his conduct. So no one heard how racist the twin boys were. No one heard how violent and aggressive the twin boys were. No one heard about the school records of the twin boys. No one heard that. All because they held whatever the hell Karmelo Anthony had in his phone and other things that Karmelo Anthony has done. Whatever he's done, he was ashamed. His mother was ashamed. His father was ashamed. They was ashamed with putting it out. I would have put that motherfucking shit out. Do you hear me? I would have put it out my goddamn self. Whatever it was. I don't give a damn if he had a picture, dick pictures in his phone or pussy pictures. I wouldn't give a flying fuck. I would have put it out. I would have put it out first because I'm sure whatever he had, the Metcalf boys was worse. Period. Fuck out of here. Fuck out of here. What did he have in there that was so damn damaging? Huh? What did he have in there that was so damn damaging that ain't a 17, 18, 19-year-old boy ain't done? What did he have in there? He fought in school, so fucking what? We all fought. I fought in the 5th grade. The fuck? What did he have in there? He said the conduct in itself isn't the problem. The fact that the state already finished their case and the defense didn't have time to go with their original plan. Exactly, that part. That part. The state had finished. The state had already got past all the testimonies of the witnesses, and none of the witnesses told that these twin boys were punks and bullies and aggressive persons, right? So because the state had finished their part, he's like, oh no, we're going to open up the whoop ass on Karmelo. Do what you got to do, and we're going to open up the whoop ass on Karmelo. Yeah, they played him. The prosecutor played Mike Howard, which essentially played Karmelo and his family. They got played. They got played. See, I'm a little bit more aggressive. I don't give a damn. I live my life like, okay, you can know everything about me, and I ain't no shame in my game. I would have put it on the floor, baby. I would have put it on the floor. I don't give a damn. The prosecutor punked them. The prosecutor punked Mike Howard, and he fell for the okie doke. He fell for the okie doke. And his mama and daddy, they let him because they didn't know no better. Amora, what was he gonna bring up? Wasn't Karmelo a good kid? You said, Amora, what was he gonna bring up? Wasn't Karmelo a good kid? As they said that he had something in his phone. Hold on. What did Karmelo have in his phone? Did they ever say what did he have in his phone, or what conduct did he have that they were so afraid of the jury hearing about? Let's find out. The fuck. We may never know, but I think we might find out on the next trial, because I think that they won't be so dumb into being embarrassed, because ain't shit that he could have done. What'd he do? Did he rape somebody? I mean, damn. What did he do? Hell, I want to know now. What did Karmelo do? They said he had something in his phone.
From what this exhibit shows, they do not actually tell us the specific contents of the phone. They do not list text messages, photos, videos, searches, social media posts, or anything like that. What they say is much more general. According to Mike Howard's affidavit, the state had a notice of extraneous offenses and bad act evidence. That notice apparently included things related to Karmelo's cell phone contents, his school disciplinary records, and other alleged character or reputation evidence. But Exhibit 10 does not lay out exactly what those items were. So we have to be careful here. We cannot say Karmelo had this or that in his phone because the exhibit does not show us that. What we can say is that the defense believed the phone evidence was potentially damaging enough that they wanted to keep it away from the jury. And that is where the alleged agreement becomes important. The defense says the state agreed to try the case clean. In plain language, that meant both sides would focus only on what happened under the tent that day. The defense would not bring in bad character evidence about Austin or Hunter Metcalf. And in exchange, the state would not bring in bad character evidence about Karmelo. So the concern was not just the phone by itself. The concern was the whole package: phone contents, school records, possible discipline issues, alleged bad acts, character evidence, and reputation evidence. The defense was afraid that if Karmelo testified, the state would say, "You opened the door," and then the jury could hear all of that. That is why this matters so much. The defense is basically saying, we built our whole strategy around this agreement. We did not bring up certain things about Austin and Hunter. We limited our witnesses. We limited our questioning. We did not call certain experts. We believed Karmelo could testify about what happened under the tent without the state bringing in all this extra damaging material. But then, according to Exhibit 10, when the defense got close to calling Karmelo, the state allegedly took the position that the agreement did not cover Karmelo if he testified. That put the defense in a terrible position. If he testified, they risked the state bringing in the phone contents and other bad act evidence. If he did not testify, the jury never got to hear directly from him about self-defense. So the cleanest way to say it is this: we still do not know exactly what was in Karmelo's phone. Exhibit 10 does not tell us. What it does tell us is that the state had phone contents, school disciplinary records, and other alleged bad act evidence that the defense was afraid could be used against him if the door was opened. The defense says they relied on an agreement that this evidence would stay out, but when it came time for Karmelo to testify, that agreement allegedly broke down. That is the issue. It is not that the exhibit proves what was in the phone. It proves that the phone evidence was part of the bigger fear hanging over the defense strategy.
No, he's done something, because I heard early on that he had got in a fight, or he had some type of disciplinary thing that happened to him in the school. So he did have something that happened. I want to say he was in the 10th grade or something. He may have gotten in a fight or something like that. But that's still, I wouldn't give a hot diggity hot dog damn what I did in my past. It still would not have hurt him, in my opinion, worse than them saying that Austin is known to be a damn bully and fight all the time. Like, because you had people, witnesses, come up there saying that Austin said, "I don't want to fight you, man. I don't want to fight you, man," which was a bullshit ass lie. I do not believe that at all. So anyway, we already been in 2 hours and 46 minutes. I don't want to stay too much longer, because the live is going to be too long and no one's going to want to replay this long of a live. So we're going to pick back up tomorrow and see what other these exhibits that we could break down and get down to the real nitty gritty. Wait a minute. I think I asked them, was there, what did I ask? I think I asked, is this what they're taking up to the appellate court? Did I ask that? Okay, if I didn't, I'll ask tomorrow. I thought I did, but maybe I didn't. So right now, this is just a request for a new trial. Basically, you heard that it said that the judge at this point could deny it flat out and say, no, you're not getting a new trial. Or they could just wait the time out, and that still equals no, you're not getting a new trial, right? So I don't think Roach is going to allow a new trial. He already came out and kind of said that everything went well and everything went right. So I think he was really happy about sentencing Karmelo to 35 years in prison. However, I don't see him offering a new trial, but I do see it going up to the appellate court. And I think some of this stuff is going to come out, more of it. But I don't think that Judge Roach is going to allow certain things to come out right now at this level, okay, the district court level. I do not believe so. I think it's going to have to go up to the appellate court, and then we will have to see what's going to go on from there. She said Mike got tricked into a bad decision deal or a bad deal, because I agree, whatever he did could have been mitigated. Exactly. He got bamboozled. And hell, I thought they told me he was a good ass lawyer. She said, Amor, do you think there will be another trial, or if Karmelo will be brought home? I think that the appellate will look at it, and will it be another trial? If the, to be honest with you, I think that, I'm not a lawyer, and I'm confident that these attorneys know what they're doing, right? However, I thought that actually it would be more, but I mean, more going up to the appellate court, like more errors. I really thought that it would be a list of them, like not just 4. But from what my chat GPT says, that at least 2 of their arguments are very, very strong. Now, we wouldn't have never thought that they were strong enough to have another trial. However, they thought that it was enough. But offering or asking for a new trial is just one step, right? That's just one step in a long process, because after this, then they go up to the appellate court and other things become an issue. These 4 things are not the only thing that the appellate court will have to address. Okay. So do I think there's going to be a new trial? I think eventually either he will have a new trial, or I do. I think there'll be a new trial. I do. I think there'll be a new trial, because I think once it goes up to the appellate, more things are going to come out. And I think ultimately he will have a new trial, because I think they're going to throw out the conviction of guilty of first-degree murder, because he ain't guilty of first-degree murder. He is not guilty of first-degree murder. The fuck? He's not. He is absolutely not. And I do believe that the judge gave the wrong jury instructions. I do. I absolutely do. There is no evidence outside of the prosecutor asking every last one of the witnesses, who provoked it? Karmelo or Austin? Who provoked it? Karmelo and Austin. And you got all these witnesses saying that Karmelo provoked the incident. They ain't no motherfucker. Who are they? Who is them? They his friends. They were his friends. Of course they're going to say that. That was not for them to decide who provoked it. Just say what the fuck happened and let other stuff, play out. So nevertheless, I do believe it's going to be a new trial, but I don't think this soon. I don't think the judge going to come back and be like, all right, I fucked up. Let's come back and do a new trial. Do I think that's going to happen? Hell no. Hell no. But do I think ultimately, after the appellate court gets involved and this, that, and the other, maybe even the Supreme Court? Yes, I do. I do believe that Karmelo Anthony will be afforded a new trial, because I do not believe his conviction of first-degree murder I don't think it was valid. I think it had everything to do with how the prosecutor set it up. And I also think it has everything to do with how the judge gave the jury their instructions. Okay? Exactly. There was no evidence that this was premeditated or that he provoked it. There was no evidence that he provoked it. So she said that judge is retiring. Yeah, but I read up on this, Super Leo. Even though he's retiring, he can actually come back and deal with this case. He can actually be, kept back to deal with this case. So we're about to hop off. We're going to pick back up tomorrow. I'm going to read a little bit more of the affidavit and find out if I can pull out any more meat. I'm sure it is, because, I didn't go over the whole entire thing. So I didn't want to do the whole thing in one day. I wanted to kind of, let y'all know how it's going and how it's flowing. But we will pick back up tomorrow and talk about it some more. Okay. She said he wants to stay on this case. Oh, yeah, he wants to stay on this case, baby. This is his baby. He's like, oh, let me just put one more black little young boy in prison for 35 years, and that's going to just make my dick hard or something like that. He said, all right, something like that. But nevertheless, I just feel that the prosecutor screwed Mike Howard, and it makes me think that Mike Howard was not as good as People were saying he was, because I actually thought I heard he was a good attorney, but you can't say you good and you got screwed on this one. But I do like the fact that Mike even says in his affidavit that it prevented him from being able to put on a defense. Right there alone is ineffective counsel. So you can ask for a new trial when there is ineffective counsel. And he even admitted in so many words that he was ineffective. He was not able to defend him because of the breach of agreement that was shook without being put on record. So Mike even pretty much saying himself that he had no way to defend Karmelo Anthony in the way he needed to be defended because of the breach of agreement. So in itself, in a sense, Mike is saying he was ineffective in defending Karmelo Anthony. Okay. So I do believe there'll be another trial. I just don't know when. Okay. Y'all, it's late. What time is it? Oh, it's 10:45. I did not mean to stay on that long, y'all. I do apologize, but y'all, this is crazy. All right. So thank y'all so very much. Thank y'all for the super chats. Thank you for the 27 lovely months. A true loud talker. Love you more. I love you back. Thank you, Kimberly C. Thank you so much, Shantae. Thanks for covering this case. Love you more. I love you back. Thank you so much, Vanita Spears. He will be free. They dead wrong. Dead ass. You hear me, Vanita? Thank you, darling. Thank you, big sis Glenn. Thank you, big sis Barbara. Thank you, Lisa. I pray he gets a chance for a fair trial. I do too. Thank you, Candy. Amore, look at the chat. Girl, you know when I be getting it going, I don't even be looking, but I'm sorry, Candy girl. I do Bella. Okay. Thank you, Kimberly T. I appreciate y'all. Listen, let's come back tomorrow and let's continue this conversation. Let me read a couple more of you guys' chat. She said, I believe in praying he gets a new trial. His Sixth Amendment right was violated. Majority. Yes, I believe so as well. How you say your name? Kayla? Yeah, I think it's Kayla. New trial will have the same results. Okay, well, we'll see if the new trial have the same results. I actually don't think so, because I do not believe he's guilty of first degree at all. Okay, maybe manslaughter if it's not self-defense. If they can't prove that it was self-defense, then maybe manslaughter, but definitely not first degree. Okay, I do not agree with that at all. Thank you, great show. Thank you so much, Madden Sykes. Is that how you said Maiden Sykes? Thank you so very much. And thank you for one of my moderators. She said, thank you everyone for your support. We do appreciate you guys. On your way out, can you please hit that thumbs up button? And guess what? We're going to discuss this again tomorrow, y'all. All right, love y'all. Good night.
Because they can't make $1 without mentioning down one of our names.
Yay! She kept talking about that family.
Hoes over there.
She kept talking about that family. 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 That family. She kept talking about that family. Talking about that family.
These motherfuckers got me want to regret something. Because they can't make $1 without mentioning down one of our names. Talking about it. That family. That family. That family. Yay! That family. That family. Talking about it. Talking about it. Talking about it.
Child, we finna talk about this with a moral.